Hey you! Welcome back to another vlog and Happy New Year! To celebrate the start of a new year, we are happy to announce that we finally reached over 1,200 subscribers. Thank you all so much. I'm glad that you find some value in the videos that I create. As some of you know, I started my own law firm a few months ago, so in this vlog and the next, I will be focusing on answering your legal questions in the field of personal injury, immigration, appeals, and wills and trust. Today, I want to discuss one of the questions I get asked a lot when it comes to personal injury, which is, if I get into a car accident and I was at fault, can I still be compensated? Well, the answer is it depends. It depends on the state that you live in. Each of the 50 states applies one of these two key concepts in the world of negligence law. First is comparative negligence, and the second is contributory negligence. Simply put, if your state applies comparative negligence, then you can get compensation. But if your state applies contributory negligence, then you are out of luck because you cannot recover. Today, I will discuss these two key concepts further, what they mean and how different states apply them. Let's get started. You see, personal injuries such as car accidents are governed by laws on negligence. In law school, we were required to take courses in torts which discusses negligence. We were told that the elements of negligence are duty of care, breach, causation, and damages. We can discuss those concepts here, but this video would be longer, and it would not really help the general public in my opinion. So I will save you the legalese and try to explain it in simpler terms. The oversimplification of negligence is that something happened, such as a car accident, caused by someone who was careless, typically the defendant, and someone was hurt, the plaintiff, because of the accident. Even though it was not the intention of the defendant, someone was still injured, so we will determine who was at fault and to what extent. First, let's talk about contributory negligence. This is the traditional approach where if the plaintiff, meaning the person who is suing, is found even slightly at fault, they cannot recover damages. Let's give you an example. Suppose you are in a car accident where another driver ran a red light, but at the same time you were slightly speeding. If a court finds that your speeding contributed even minimally to the accident, you would be barred from recovering any compensation for your injuries from the other driver despite their more significant fault. There are 5 states that still use this principle. Can you guess them? Well, these 5 states are Alabama, Maryland, North Carolina, Virginia, and DC. Now, this is not to say that you can't recover anything from your own insurance, so we can discuss that further in another video. On the other hand, comparative negligence is more forgiving. Here, the fault is divided among the parties involved. There are 2 types of comparative negligence. One is pure and the other is modified. Under pure comparative negligence, plaintiffs can recover damages even if they are 99% at fault. While under modified, there's typically a 50% or 51% fault threshold. New York applies pure comparative negligence. So in the same scenario as one earlier, if that happened in New York, what would be the effect? The court, through a jury or a bench trial, will compare fault. The judge or the jury will assign the percent of fault for the plaintiff as well as for the defendant. If the court determines that the defendant was 80% at fault and the plaintiff was 20% at fault, then the plaintiff can recover, but that amount is reduced by 20%, accounting for the 20% that the plaintiff was at fault. In the same manner, if the plaintiff was 99% at fault and the defendant was 1% at fault, the plaintiff is still entitled to that 1%. Other states that apply pure comparative negligence would be California, Alaska, Arizona, and Florida. Now let's discuss the modified comparative negligence. Let's take New Jersey because it applies modified comparative negligence. In Jersey, if the plaintiff's negligence is not greater than the defendant, the plaintiff can recover but will find his damages proportionately reduced. So the same scenario, but if this happened in New Jersey, what would be the effect? In the first scenario, the plaintiff can still recover because the defendant was more at fault. But in the second scenario earlier, where the plaintiff is 99% at fault, the plaintiff cannot recover because the rule in New Jersey is if the plaintiff is 51% at fault or more at fault than the defendant, then the plaintiff cannot recover. So New Jersey basically says, yes, we will compare fault, but if the person suing is more liable for the accident, then he should not be allowed to get the money from the defendant who was less at fault. Aside from New Jersey, some of the states that apply modified comparative negligence would be Texas and Illinois. Let's recap. Auto accidents are governed by negligence. Each of the 50 states apply either contributory or comparative fault. There are two types of comparative negligence. One is pure and the other is modified. Think of contributory negligence as the strict type of negligence. In these 5 jurisdictions that apply contributory, you can only recover if you were not at fault. In New York, on the other hand, and other states applying pure comparative negligence, you can recover even if you are 99% at fault. Lastly, in New Jersey and other states that apply modified comparative negligence, you can recover only if you were 50% or less at fault than the defendant. So I hope that makes sense, and the next time you move, make sure you know whether you're in a contributory or comparative negligence state because it can significantly impact you if you get into a car accident. Thanks for watching, and don't forget to like, share, and subscribe for more legal insights. See you in our next video.